All right, well, welcome. I'm here with Bryan Montana. He is a estate attorney with Chuhak and Tecson, and we're going to talk a little bit and dive deep into the estate planning realm today. I really want to start here first, the wealth transfer. You hear it in the news and kind of all over that we're going to see the older generation pass down all these assets,
Right.
and people are going to start inheriting that. So where do you come in that case?
Yeah. Good question. So I often view my role as an estate planning attorney as sort of like the defensive coordinator of a team, right? You have your wealth advisors and other people who are helping people grow their assets, right? That's the offensive side of things. And then on our side of things, we're trying to help people protect what they worked so hard to build, right? Protect it from things like taxes, from probate and other administrative costs, and from other things that might chip away at what they're trying to pass on to the next generation.
Yeah. I kind of like that analogy of like the football, you see two sides of it. So having a good defensive side in your corner is huge help.
Right. It's also why it's so important, further continuing that analogy, for professionals to be communicating, for your tax people, your legal team, and your wealth management team to all be on the same page communicating. So, that when you know what the other side of the ball is doing, it's a lot easier to plan on your side.
Yeah. And I kind of want to maybe take a step back real quick and just maybe tell our audience, what is the basics of the estate plan?
Yeah.
What is it?
Yeah. So estate planning, one of the questions I get is, do I have enough money to need an estate plan? Well, the question really becomes, well, what is an estate plan, to your point? And your estate plan changes throughout your life. Many people view it as a set it and forget it, or a one-time cost. I got to go see a lawyer. I got to go pay him money and put my estate plan in place. Or people will say, oh, I already have an estate plan. I'm good. Well, the problem is your estate plan changes throughout your life. Think of, imagine you're trying to plan for a vacation, but you don't know when the vacation is. You don't know where you're going, so you don't know what the climate's going to be. And now you have to plan for it. So you have a suitcase. What do you put in the suitcase, right? How big of a suitcase do you need? Do you need to bring warm weather clothes? Do you need to bring cold weather clothes? Are you going to gain weight between now and then, or are you going to lose weight? Or are you going to be about the same, right? So maybe you need to go shopping. Estate planning is kind of like that. Which is what makes it so difficult, right? Mm-hmm. Many times the first time I'm meeting with people about their estate plan is when they have children. Because when you have children, you immediately start thinking about, well, what happens if something happens to us, and now we have minor kids who are on their own, right? So that's sort of the first step when most people go to see someone like me about getting their estate plan in place. The fact of the matter is most of the people I'm working with already have some type of estate plan in place, whether it's wills and powers of attorney that they did, 25 years ago, or some type of trust or multiple trusts, right, that they may have in place. You can think oftentimes of the trusts as the suitcase on that vacation, right? Sometimes you need multiple suitcases. Sometimes you need a bigger one or a small one, right? Mm-hmm. Many of my clients who do your most basic estate plan is going to be a revocable living trust, last will and testament, a healthcare power of attorney, and a financial power of attorney. Those are sort of the core documents in most estate plans. Now, most of my clients who have that type of estate plan, when their kids turn 18, I do healthcare and financial powers of attorney for their kids, right? And the reason is, once they're 18, if they go off to college, right, now their parents they're no longer their legal guardian, so they can't talk to their doctors. They can't access their bank accounts or help pay their bills, right?
Yeah.
So if something happened to I have a client who is, their youngest son went off to Colorado. So we set up those powers of attorney so that if something happens, heaven forbid, while he's off at school, mom and dad have the ability to act for him legally, right? So, an 18-year-old needs an estate plan, but he probably doesn't need a trust yet, right? I'll tell the story about, I have a family member who reached out to me right after they had kids, and they said, can you help me put my estate plan in place? And we started going through their situation, and they were still renting, didn't really have a ton of assets, had their retirement account through their employer, and they're still young and building their assets. So at that point, I said, really, you need simple wills to name guardians for your minor kids and powers of attorney. It was really straightforward. Well, fast forward 10 years for that same couple, then they needed revocable trusts, right? Because now they owned a home, and they had, the wife had inherited a partial interest in a vacation home in northern Michigan. So there were some things that we needed to add on to the estate plan. Kind of a long-winded answer to your question, but you can kind of see how the situation is different for every family, and it changes throughout that family's lifetime.
And I like that you touch on family, because I think that's a really key part of estate planning. So I want to dive a little bit deeper on that and go with family in an estate plan. How do you bring up that topic? Because it is a difficult topic to bring up to your family members that you love and care about.
Yeah.
How do you do that in a way that doesn't seem like
pushy or intrusive? Yeah. It's definitely a challenge. So my background, I spent 10 years practicing in the area of estate planning called elder law. And elder law focuses on the estate planning needs of seniors, and usually people with assets, but not the ultra high net worth space, right? And so we're focused in those situations on how do we, again, playing defense, protect what they have from probate, taxes, but also long-term care costs, right? So oftentimes in that situation, we had two types of clients. We had what we call proactive planning and reactive planning. Proactive planning were people who were in their 50s or 60s, approaching retirement or so, and they said, now that I'm retiring and I've accumulated these assets, how do I put a fence around them and protect as much as possible, right? So that's people thinking proactively. It's a lot easier because those people often seek you out for help. The reactive side is more of an emergency, right? Something happens in their life, whether it's a loved one dies. Oftentimes, someone sees what happens to their parents, and they realize their parents didn't plan as well as they could have. And they say, I'm not going to let my kids go through what I went through. And so then they come see me and say, Bryan, here's what happened with my parents. How do I make sure that doesn't happen to me and my spouse and my kids? And that sort of real life lesson, it's kind of like my wife and I were having this conversation with our son. That's called learning the hard way. Is sometimes it's not ideal, but it really reinforces the lesson.
Right.
So your question, how do you have those tough conversations? Sometimes it's the children driving the conversation for their parents. Other times, these are conversations I'm having with your parents, with people's parents, saying, you need to be having these conversations with your kids so that they know, they may not need a robust plan now, but so that they know the types of things that they should be doing when they accumulate their own wealth, and also when they inherit, right? Statistically, we know people inherit money poorly, right? It's like the lottery effect. If someone wins the lottery and you don't have that sense of earning the money, you don't always do the wisest things with it. So I think it's important that when you are passing wealth, particularly when it's generational wealth, large amounts of money, that you're having those conversations with your children, just like you would teach financial literacy to your kids, right? Teach them about, paying off your credit card each month and all the sorts of things that many of us, including myself, had to learn the hard way.
Yeah. And then, so I know you touched on a little bit of like why you want to do estate planning, but you might not have touched on like what is probate and like why do we want to maybe avoid that, or what are some of the headaches caused from not doing an estate plan?
Yeah, it's a good question. So probate is basically when your will gets submitted to court. Court interprets the terms of your will, appoints an executor, person that's named in your will, and passes things on to your beneficiaries, your kids or grandkids or whoever's named in the will. Well, because that process is supervised by court, it means it's more expensive. It means it takes a longer amount of time, sometimes years, to get those assets to your kids or grandkids or other loved ones. And so avoiding probate means if you know where you want your assets to go, we can avoid involving the courts and minimizing involvement of lawyers, sometimes completely avoiding the use of lawyers depending on the situation, to make sure things, the big picture is we want to make sure whatever you've accumulated, whatever you've grown your nest egg to, as much of that as possible gets passed on to your kids without getting nipped at by legal fees and taxes and other expenses. So avoiding probate really is about minimizing the hassle and the expense associated with passing things on to your loved ones. So it sort of begs the question, well, how do you end up in probate, right? And the easiest way you end up in probate is when you have something in your individual name and you die without any sort of estate plan in place. It's called dying intestate. It just means you died without a will. So people think, well, if I have a will, I don't have to go through probate, right? Well, wrong. A will is actually like a one-way ticket to probate court. All you have is a will. That will has to be administered by the probate court. Well, how do I avoid probate? Now, every type of asset and every type of family situation is different. Jointly owned assets usually pass to the joint owner, so they avoid probate when the first owner dies. But the main way we avoid probate is a combination of beneficiary designations on financial accounts and the use of trusts.
Okay.
If something is in a trust, it automatically avoids probate. If it's not in a trust, we usually want to make sure there's a beneficiary designation on that asset, whether it's a bank account, life insurance policy, an IRA, 401k, or other investment account. So we kind of go through that process, and this is where communication with the wealth advisor is so important. When I set up an estate plan, the first thing I do after we sign the documents is call the wealth advisor to say, okay, here's what we've set up. Here's the name of the trust. Here's what I recommend as far as what you put in the trust, what you do with beneficiary designations, and then we're working together to make sure the client's accounts get updated.
What is the asset level that you think would be that someone needs a trust?
Yeah.
Or when do they need to start thinking about, hey, I've accumulated some assets. How do I need to give you a call?
Sure. So, and this goes back to a conversation earlier about your estate plan staying updated throughout your life. Trusts do a number of things, and there are a number of situations that may dictate that a trust makes sense for you, right? I think it's helpful to look at what does a trust do as opposed to what happens if somebody doesn't have a trust, right? One, the trust avoids probate. So sometimes we're doing a trust purely to make it easier to avoid probate. And I talked earlier about beneficiary designations. Both options avoid probate, but sometimes trusts are a more efficient way to do it. And some assets you just can't put beneficiaries on, or the way you want to set it up isn't possible through a beneficiary designation. So for example, I had a client once who had a bank account, and she wanted that bank account to be split between 6 different people with different percentages. It wasn't equally between 6 people. Well, her bank would not let her name different percentages for these different beneficiaries. I have another client who has a child with special needs, so the child has a special needs trust. Mm-hmm. Well, so now we're designating 2 of the kids as beneficiaries, but the third child's share is being transferred to a separate trust for the benefit of that child. So those types of customizations sometimes are easier to do through a trust. One of the other big reasons we do trusts is to prevent your kids from having access to the assets too soon, right? So if you passed away and if you don't have a trust, your child's getting full access to their full inheritance when they turn 18, right? So I know what I would have done with money when I was 18, a freshman in college, and it would not have been to go to Raymond James to say, help me invest this money. It would have been gone pretty quick, right? So the point is we want to protect our kids from themselves. Most of my clients say, look, if I'm giving things to my kids, I don't want them to have full unfettered access to their share until they're 25 or 30. Now, so what do? The trust names someone else that they trust to manage the assets and decide when to give the kids money, for example, for college or for medical bills or to put a down payment down on a first house, until that child hits the age at which we think it makes sense for them to take over as trustee of the trust. The other benefit of passing things in trust is because the assets, if it's set up correctly, stay in trust for the benefit of the kids, you get really good asset protection benefits, meaning creditor protection. So if that child inherits $1 million and then they get divorced, well, that spouse, that ex-spouse, can't go after what they inherited in their trust because it's protected from that child's creditors, right? Mm-hmm. Whereas if you just name your child as beneficiary on that account and they inherit $1 million, now it's theirs. So it's much easier for a creditor, including a spouse, to go after the assets. So, sorry, long-winded answer to your question of what asset level does it make sense for someone to need a trust? And it just depends. In the state of Illinois has a separate estate tax or inheritance tax, separate from the federal, right? The federal amount is such a high amount now that most Americans don't have enough money to need or to reach the point where they're going to owe federal estate tax. Illinois, at $4 million, you start owing Illinois estate tax when you die. So if you have a married couple with over $4 million, right away, without getting into all the details, they almost certainly need a trust to minimize how much is going to get taxed. Right? So, very long-winded way of answering the question. The lawyer's favorite answer, it depends.
Yeah. No, I totally get that. And then, so you kind of touched on the law part, and that's your expertise, but the laws are always changing.
Yeah.
How are you guys keeping up with that? And how often are the estate planning laws changing or affecting clients?
Yeah, I think, they're always changing, sometimes more significantly than others, but it's very important for us to stay up to date on this area of law, which is why I think it's so important to not dip your toe in this area of law. Just like I try not to step outside my area of expertise. If somebody needs help with a divorce or with a personal injury suit or, bankruptcy, I'm going to find an attorney that's an expert in that and refer that out. I think when it comes to estate planning, it's really important that your estate planning attorney and your other professionals, your wealth advisors and your CPAs, are staying up to date on the law. Just from a personal career development standpoint, I try to stay up to date and publish articles, post to LinkedIn with information on changes in the law, like the most current being the new Trump tax code, the beautiful bill, right? So we've posted on that. We posted on some of the main provisions that impact our clients under that law. I think it helps people realize that this is something that we're staying on top of.
So I want to, that's a great answer. I think
thank you.
It's important to keep up to date no matter what, like even for me, and just to have the client's best interests. But I want to switch back a little bit and say someone is working with their CPA, wealth advisor, and then they decide they need a trust, an estate plan. What does the process look like from hiring you to establishing that trust?
Yeah, it's a really good question. So typically my process involves someone reaches out to me, whether it's the wealth advisor or the person that's recommending the client come speak to me, or the client directly. We typically do an initial sort of intake call, whether a meeting, either in person or over Zoom or on the phone, and just kind of find out a little bit more about what's going on with them. I'll make usually initial recommendations, and depending on how complicated the plan is, sometimes we're doing it in multiple stages, right? We're updating the basic estate plan, and then sometimes we're creating family limited partnerships or LLCs, or restructuring how they own things. But the simplest process is intake. I'm hired. I draft the documents. I send them the draft with a cover letter that says, all right, you just got 120 pages of legalese. Here's what it means. All right. here's the healthcare power of attorney. Here's who you've named. Here's what this document does. Here's how the trust is set up. Here are the decisions you've made. We'll usually do a call or a meeting to go through and answer questions. Then we get together and sign the documents. Okay, so once the documents are in place, then comes the step of actually funding the trust. Funding the trust meaning updating titling of your assets, how your bank accounts, your investment accounts, your life insurance, your real estate, how everything is titled, whether it's in the name of the trust or designated with a beneficiary. So that's sort of the initial process. That process typically takes about 1 to 2 months from our first phone call to when we sign the documents. And then it's a matter of keeping that plan up to date. And every client's different. There are some clients where I have phone calls with every year talking about, okay, what's changed? Sometimes it's a 5-minute phone call. Other clients don't reach out to me until something major's changed, which becomes difficult sometimes because they're not necessarily keeping up to date on all the changes in the law, and they may not know when something's occurred that requires their plan to be updated. So I encourage people to reach out every 3 to 5 years at most, just to talk about, hey, what's changed? What's changed with your family? What's changed with your finances? It's kind of like, if I'm back to the vacation planning analogy, it's like, okay, well, we're getting a little bit more certainty. Now we know we're going to a warm climate. So it's a matter of modifying that plan as things change.
Well, this has been great, and kind of wrapping up a little bit, I want to touch on you a little bit more personally. What's been your favorite part about estate planning and law in general?
Yeah, I mean, estate planning is a great area of law. I look at my friends who do some of the more contentious areas of law, divorce and litigation, and I certainly admire that area of law and what they do. But my clients generally, like your clients, are very happy with me, and I'm talking to them in situations where they like to talk about things like, they've grown their assets, they have assets, they're talking about passing things on to their kids. Is generally a happy conversation. Right? Certainly sometimes people come to me in situations where there are difficult life or family circumstances, and that's very important as well. I mean, that also makes me feel good that people come to me when they have issues. And sometimes it's not necessarily estate planning related, and clients will call me and say, hey, my daughter bought a car and that car broke down on the side of the road. Is there anything I can do to, get reimbursed from the dealership? It's an excellent question. Let's try to help find an answer for them.
Right.
But I think it just goes to show that when people view you as a trusted advisor, they'll come to you for solutions that might even be outside of your area of focus. So I love that. Yeah.
Well, it was great having you.
Thanks.
And we'll throw your information here on with the video, but thanks for coming and appreciate it.
Yeah, this is awesome. Thanks. Appreciate it.